subscribe to our channel and press the bell icon to never miss a video from LiveLaw.
Hello everyone, I'm here to introduce my new book, The Cases That India Forgot, as well as to discuss one of the cases that I analyzed in the book. So let me start briefly with what the thinking was behind writing this book. A large amount of legal scholarship that we see in India today takes place in non-traditional sources, so not necessarily behind paywall journals, but it often takes place in newspaper articles, in periodicals and the like. And the reason for which it takes place in such sources is in order to make it more inclusive, in order to make it more accessible. But some of the feedback that I had received was that a large amount of this scholarship is nevertheless fairly legalistic and difficult to access for those that lack specialist knowledge in the law. So the primary impetus behind this book is to increase citizen engagement with the law in general and the Constitution in particular, and to write in a manner that is reasonably sophisticated yet accessible to a wider audience. In this book, I consider 10 cases that are not in the public consciousness, but that I say should be, because those cases are of some social, legal, political or other significance. Those cases are divided into 4 themes. They are politics, gender, religion and national security. There's just one important point to be made, and that's about socio-political context. And my endeavor in this book has been not merely to provide a plain language translation of the cases that I've considered, but also in addition to bring those cases to life through a description of the narratives and explanation of what takes place both before and after the cases were decided. I think the reason for this is, and the reason this is important, is that we often tend to think of judgments as text, whereas judgments can more accurately be conceived of as performance, as the culmination of a process. With that, let me take you through one of the cases that's been discussed in the book. That is a national security case, the case of Kartar Singh. And just by way of background, the Kartar Singh case involves TADA, or the Terrorist and Disruptive Activities Act. This was a statute that was enacted in the 1980s. It's a law from 1985. And some of you will remember this, but by way of background, it was enacted in the context of militant groups engaging in guerrilla-style conflict in several parts of the country, including the Northeast, as well as in Jammu and Kashmir and Punjab. If you delve into the parliamentary debates at the time that TADA was enacted, they were full of histrionics. So for instance, one member of parliament describes the atmosphere at the time by saying that at one point milk used to flow through the rivers of Punjab, and now blood flows through the rivers of Punjab. Another MP says that these are not normal times, we live in extraordinary times, and it's those extraordinary times that necessitate a statute such as TADA. Now, what was so special about TADA? What was special about TADA was that it in effect set up a parallel criminal justice system for those accused of terrorism offences. And it did so in a number of ways. First, it reversed the burden of proof and placed the burden of proof upon defendants in circumstances where the prosecution would ordinarily bear the burden of proof. The second, and this was quite a remarkable change in the law of evidence so far as TADA cases were concerned, was that it made confessions provided to police officers of a certain seniority admissible in evidence. This was one of the rule that evidence provided to police officers should not be admissible is one of the key safeguards against custodial torture. This was reversed by Tada. In addition, Tada made it harder to get bail, and this took place in two respects. First, there was a denial of anticipatory bail altogether, and second, it also made it more difficult to secure bail following arrest. Finally, Tada eliminated one layer of appeal. So within the ordinary criminal justice process, you'd have an appeal from the trial court through to the High Court, following which you have an appeal to the Supreme Court. Tada eliminated the right to appeal to the State High Court, providing for a direct appeal to the Supreme Court. Now, the one interesting thing to note about Tada, and you'd see this in respect of a large corpus of national security legislation, is that it was both temporally and geographically restricted. And what do I mean by that? As regards the temporal restriction, Tada was meant to be in operation for 2 years only at the outset. In addition, there was also a geographic restriction. And what I mean by that was that the initial understanding was that Tada would be applied only in Punjab and in neighboring regions which had a consistent history of terrorist violence. Both of these promises were not complied with because on the one hand, the temporal restriction was extended over and over again. So 2 years became 4, 4 became 6, and 6 became 8. And the geographical restrictions were considerably relaxed as well. And so therefore, over a period of a number of years, Tada was extended all across the country to the point where a few years after it was enacted, it applied to 23 states and covered 95% of India's population. Now, soon after Tada was enacted, petitions began to be filed, challenging its constitutional validity. So these are filed beginning the middle of the 1980s. And estimates suggest that by the year 1991, about 1,000 or over 1,000 petitions had been filed. A leading criminal lawyer at the time, R.S. Sodhi, a gentleman that defended many many of those charged under Tada, was asked in the year 1991 whether he expected the petitions to be heard anytime soon. And his response, his very honest response, was that he didn't expect them to be heard anytime in the near future. And he was right, because those challenges were heard by the Supreme Court only in the year 1994. So there's a lapse of 9 years between when Tada is enacted and when the challenges to Tada are considered by the court. Now, what happens in the interim, in those 9 years, where Tada remains on the books without the challenge being considered? I think the simplest way of putting it is that the process under Tada was the punishment. Conviction rates were estimated to be very low, between 1 and 4%. But Tada was predominantly being used as a preventive detention law. Let me give you a few real-life examples of the human suffering that was caused when Tada was applied in that intervening period. So there was one instance where 2 men were detained for a period of 2 years for causing ruckus at Baikala market in Bombay when they had a gun which was ultimately found to be a toy gun or possibly a pitchkari. They were detained in prison for 2 years. Then we have another case where 3 boys spent 4 years in prison charged under Tada because they had in their possession Sutli bombs, which are well known as being used as fireworks during Diwali. Tada was also routinely used in frivolous cases. So there was a case involving a garment exporter who was charged of tax evasion. This exporter was based in Bombay. He was once again charged not just under the ordinary law or under the law relating to tax evasion, but also under Tada. There are several examples of Tada being misused as a preventive detention law. One of them involves a case in which a man chased a driver with a knife, clearly revealing some kind of offense, but probably not a terrorism offense. He was initially charged under the IPC. He secured bail, but the police was incensed with the fact that he managed to secure bail. So what do? They charge him under Tada and place him under detention once again. So these examples just explain how oppressive the law was in that intervening period when the Supreme Court failed to decide the challenge and the petitions that were filed. Ultimately, in 1994, the challenge is considered and decided by the Supreme Court. And I think it's safe to say that it wasn't worth the wait, because the Supreme Court upholds the challenge to Tada on both counts. It upholds the challenge to Tada on the basis that Parliament had the legislative competence to enact Tada, and it also upholds the legislative challenge to Tada on the basis that Tada didn't violate fundamental rights. And this was, and several sections, section upon section of Tada was upheld in this way by the Supreme Court. Rather peculiarly, at one point the court acknowledges that allowing confessions provided in police custody to be made admissible would dilute one of the key safeguards against torture. And the court acknowledges that the police is known to extract evidence by hook or by crook. But rather strangely, it nevertheless decides to uphold that provision on the basis that Parliament had the competence to enact it, which is of course an analytically separate issue. So what happens after the challenge to Tada is the Tada is upheld by the Supreme Court. At around about the same time, in the early 90s, we have a separate human rights institution which is being set up called the National Human Rights Commission. Now, the dominant narrative when the NHRC was set up is that it was established by the Narasimha Rao government under pressure from international financial institutions such as the IMF and the World Bank. The NHRC is set up under the chairmanship of former Supreme Court Chief Justice Ranganath Mishra. In the early years of the NHRC expresses open dissatisfaction with the Supreme Court's judgment in the Tada case. And so therefore it adopts a three-pronged strategy in response to the court's decision. The first prong is rather simple. It decides to monitor the implementation of the court's decision. In other words, assuming that the court's decision is correct, is it at the very minimum being complied with by police and public officials on the ground? The second prong of that strategy is that the NHRC prepared a dossier to the Supreme Court seeking to convince it that its decision was wrong and that its decision should be reviewed. The third, and I would argue most important prong of the strategy was to seek to persuade members of Parliament not to renew Tada. Remember, Tada is one of those statutes that has a sunset clause, so it lapses unless positively renewed by members of Parliament. And it becomes clear that at some stage Justice Mishra becomes personally invested in the project of ensuring that Tada is not renewed. So he writes letters to individual MPs urging them not to renew Tada. He delivers speeches across the countries, writes op-eds, writes pieces in newspapers arguing that Tada should not be renewed. At one point he goes to the extent of saying that his role as chairperson of the NHRC is unsustainable and is virtually untenable in the light of Tada remaining on the statute books. At one point, Justice Mishra actually travels to Hyderabad and makes a speech rhetorically asking how it was possible that so many cases under Tada had been lodged in the state of Andhra Pradesh when the state lacked a consistent history of terrorist violence. These efforts ultimately yielded some success, and on 23rd May 1995, Tada lapsed and was not renewed by Parliament. I think it's clearly the case that Tada was not renewed not because of but in spite of the Supreme Court's decision. This was and continues to remain one of the prominent success stories of the NHRC.